day after the UK electorate voted to leave the EU, one of the immediate questions that arose, amongst many, was whether EU citizens living in the UK and UK nationals living in other member states were still secure in their residence in those places. Unfortunately, in the months following the referendum, little in the way of concrete assurances being offered to such individuals, beyond the fact that EU law still applies in the UK for the time being, while it remains a member state. Little has been said about what happens after UK withdrawal. With Article 50 TEU, the provision that sets out the framework for a member state to leave the EU, due to be triggered in the coming days, we thought now might be a useful time to outline the key legal issues arising in the area, though clearly we can't provide specific advice since we are all somewhat blindly seeking the correct path to follow in the absence of much indication as to the government's plans. So, first I'll provide a broad outline of what residence rights EU citizens currently enjoy in the UK and UK nationals have in other EU member states, as a matter of union law. Second, I'll summarise the current government position. Third, we'll look at some of the options for securing residence rights that have been considered by other actors against that vacuum in government guidance. Finally, we'll examine and assess what is looking to be the most likely outcome, namely a political agreement between EU leaders. All EU citizens enjoy a right to move and reside freely around the EU under the EU treaties. However, for the most part, that right is realised via secondary union legislation, specifically the Citizens' Rights Directive. Under that directive, EU citizens may enter a host member state and reside there for up to 3 months with minimal formalities, just a passport or an ID card. After 3 months, an EU citizen can reside in their host state, say the UK, if they're working here, are self-employed here, or if they're not economically active, if they have sufficient resources and comprehensive sickness insurance so as not to become a burden on social assistance systems. Under the directive, EU citizens who have been residing legally in their host state for a continuous period of 5 years may become permanent residents there. EU citizens resident in the UK tend to live under these EU rules, which are different from the domestic framework that UK applies to non-EU nationals living here. Consequently, there's a question mark over whether EU citizens currently resident in the UK will be able to continue living here when the UK leaves the EU, and under what rules. Obviously, this is something of utmost concern for people who work here, have homes here, have built a family life in the UK, and the same applies for UK nationals living in other member states. In the government's white paper on the UK exit from the EU, it recognised that while the UK remains a member state, EU citizens continue to have residence rights in the UK as a matter of EU law. It also indicated that it wished to secure the status of EU citizens currently living in the UK and provide them with some certainty. However, though there's nothing legally preventing the UK government from providing such clarity now through a unilateral declaration, it asserts that there are two interrelated reasons preventing the resolution of the problem. First, it states that the UK can only secure the residence rights of EU citizens in the UK if it's assured that the other member states will reciprocate and protect the rights of UK nationals living in the remaining 27. This somewhat contradicts the government's claims that it won't use EU citizens as bargaining chips in the upcoming negotiations. Second, the Prime Minister has indicated that 1 or 2 EU leaders have refused to come to the pre-negotiating table and reach such a reciprocal deal. This stance might appear to be fair enough on first glance, but it misrepresents some key aspects of EU law, which we'll discuss more later. In the absence of anything more than this from government, a number of other actors have sought to find means of securing residence rights or second-guessing what EU citizens might have to do. The most frequently mentioned option is to secure residence entitlements for all EU citizens in the UK who enjoy a permanent right to reside here under that Citizens' Rights Directive. Indeed, the UK saw a rise of 75% in applications for permanent residence in the first and third quarter of 2016, i.e. before and after the referendum. However, parliamentary committees have already correctly acknowledged that this is far from a catch-all solution. First, those who've been residing in the UK for quite a long time, building up family and social ties here, but not for 5 years, won't be covered. Nevertheless, the UK might still potentially open itself to human rights litigation under the right to family life if these people aren't at least considered as having a potential right to remain. Second, not all individuals living in the UK under union law here live here under the directive, even if most do. Those who don't cannot qualify for permanent residence. Third, even those that appear to live here under the directive and have resided here for over 5 years might struggle to demonstrate that they have the 5 years continuous legal residence required. The most common example here relates to comprehensive sickness insurance. Let's say we have a French national who's been living in the UK for 5 years. He's been working here as a nurse for 2, and so has been residing legally during that time. However, for the first 3 years in the UK, he was a student here. He had sufficient resources to cover his needs while studying, but didn't realise that he needed comprehensive sickness insurance, and in reality didn't really rely on national health services during that period. Regardless, since he didn't have comprehensive sickness cover, he won't technically have been legally resident and may struggle to secure permanent residence. The House of Commons exiting the EU Committee recognises this problem and recommends that access to NHS services should count for the purposes of permanent residence. But the requirement of insurance beyond access to the NHS has long been Home Office policy and has even been confirmed by national courts in a pre-referendum case law. So it remains to be seen whether anything will change here. Another issue with permanent residence is one of evidence. Since the UK doesn't have an ID card system and EU law doesn't require individuals to have residence documentation to secure residence rights, many EU citizens living in the UK will be retroactively applying for permanent residence. Providing historical evidence will be difficult, particularly for those who've moved between employers or moved between residence categories, for instance like our French nurse, who was sometimes a student and sometimes a worker, with different rules applying at different times. As a result, some parliamentary committees and those ultimately failed amendments to the notification of withdrawal bill sought to impose lesser requirements on permanent residents, for example, shorter periods of legal residence. But this still raises questions of evidence and also still raises questions about things like comprehensive sickness cover. Ultimately, parliamentary committees are now generally calling for government to consider residence rights to confer residence rights on all EU citizens unilaterally. However, the government is still resisting, stating that it's seeking a reciprocal deal with the other member states. But that is more complicated than it seems. For most EU citizens, including UK nationals abroad, a right simply to be in their host state is not enough. What makes that right to reside a reality is the package of rights that go with it, mainly equal treatment rights, such as equal access to jobs, education, healthcare, social assistance, but in addition, being able to bring family members with us to our host state. If the UK will only secure these meaningful residence rights to EU citizens if the EU offers the same to UK nationals resident in the rest of the EU, it will make the withdrawal agreement more complicated, indeed, if that's how the parties wish to proceed. Specifically, while Article 50 foresees agreement on the withdrawal agreement from the EU side, with a qualified majority in the Council of Ministers and the consent of the European Parliament, an agreement on residence rights for UK nationals will touch on areas of competence shared between the EU and its member states. As a result, for the agreement to go ahead, it will need to be ratified by the 27 member states in accordance with their own national requirements. This might include referenda or getting regional parliaments to give their agreement, which complicates things. It's important to remember in this context that the EU isn't the federal superstate that some Leave campaigners would have had people believe, but an organisation with powers conferred upon it by its members. Consequently, in such an area, this isn't really about two sides, the UK and the EU, but the UK and an EU of 27 member states, each with their own experiences of UK free movement on their territories. Given this complexity, it's looking increasingly likely that a political agreement between European leaders will be reached on the question of EU and UK citizens' residence rights as part of the negotiating process, but outside that formal withdrawal agreement. But that raises its own questions. Most importantly, how that political agreement will be translated into a legal reality. The UK will presumably have to enact legislation, though Parliament appears very willing to do this. On the EU side, secondary legislation will eventually be needed, which will need to follow EU lawmaking procedures. In particular, if the EU is no longer a member state by this time, the legislation will fall into part of the treaty in which certain member states have opt-outs and opt-ins, so Denmark and Ireland will have to decide to get involved. As well as thinking about what comeback will be available for the UK if the legislation doesn't pass various stages of this EU lawmaking process, We should also start to think about how the agreement will be interpreted and how citizens' rights will be enforced, especially in the UK, outside the current legal framework. And these will be big questions spanning into the future. The most important issue to flag, however, as regards to any upcoming political agreement, is that it must reflect and find a way to encompass the breadth of rights currently enjoyed by EU citizens in the UK and by UK nationals abroad. Some of these are quite simply very technical issues that it seems difficult to envisage can be covered in a quick political agreement. One example is the EU Social Security Regulation. This allows EU citizens to collect their pension contributions across different member states that they've worked in when they retire, so that they haven't lost out on contributions by working abroad. For instance, say you need 35 years employment to qualify for pension in Germany. At the moment, 10 years spent working in the UK will count towards that, and EU rules create specific formulae for working out how much you're owed and who owes what between the member states. When the UK leaves, the EU will drop out of this framework, potentially leaving many EU citizens who've worked in the UK or UK nationals who've worked or retired abroad worse off. This is simply a very technical and complicated matter, but it will need to be resolved. So, to conclude, while it's disheartening that the government continues to resist providing reassurances to EU citizens living here, it might be seen as encouraging that it seeks early agreement on the matter, and that Parliament sees this as a key area in which it must apply pressure to government. But in the process of reaching agreement, the political actors involved must be scrutinised every step of the way to ensure that a meaningful package of residents' rights, beyond the right simply to be in the UK, is made available, and to ensure that any political agreement can be successfully translated into a legal reality.